Chairman, members of the arbitral panel, my name is Colin Dales and I am Senior Counsel for the claimant. I'm assisted by my learned friend Richard Clark, who will be dealing with the substantive points. I will be dealing with the jurisdiction point.
Mr. Dale, how is your surname spelled?
D-A-L-E-S.
L-E-S. And your friend, Mr. Clark?
C-L-A-R-K-E.
Thank you.
Thank you.
Come back to you in a moment about times when we hear from the other side. Yes.
Good afternoon, members of the panel. As a matter of procedure, the respondent wishes to make clear that this appearance is conditional on the tribunal hearing the issue of jurisdiction, and at this stage we still maintain our objection to the jurisdiction of this tribunal. My name is Susan Hedge and I appear with Michael May for the respondent, Cruisy Shipping Support.
Same question.
My last name is spelt H-E-D-G-E.
Yes.
And Mr. May's name is spelt M-A-Y.
Yes. And
Thank
I'm
you.
sorry, his first name?
Michael.
Michael. Thank you.
Mr. Dales, have you worked out how you're going to split your time in making your addresses on this?
It's our intention to take 15 minutes, approximately 15 minutes each.
All right, well, we'll get the timekeeper to give you warning of how your time's going, say after 10 minutes, and you know you're in the last 5.
Thank you.
And for the respondent, what's your...
Similarly, Mr. Chairman, we wish to take 15 minutes each also.
I see, all right, well the same will apply with you.
Thank you.
Yes, Mr. Dales.
Mr. Chairman, you should find in the bundle that we've submitted a skeleton argument. Don't know if you've had the opportunity to review that.
And the bundle is this leader arch file.
Yes.
We have two lever arch files in front of us. One is thicker than the other.
Yours is the thick one.
It would appear that ours is
Indeed.
the thicker of the two.
All right. Thank you.
Yes, we've got that.
Mr. Chairman, members of the arbitral panel, I have 4 submissions on the jurisdiction point. These are that England is the correct jurisdiction for this arbitration to be heard. The jurisdiction clause between Imagine Imaging and Fast Forwarders is imposed on Cruisy Shipping as there is a relationship of agency by which a collateral contract can be found. The jurisdiction clause contained in the head contract in the alternative can be applied to Cruisy Shipping as there is a relationship of subbailment that exists between the claimant and respondent, and the forum clause that the respondent has inserted into their standard terms and conditions fails to prevent the operation of the arbitration clause in the head contract. Moving to the bailment relationship, the Pioneer container established that in cases of a bailor giving consent to a bailee to subcontract on any terms, the sub-bailee can insert a jurisdiction clause if they so wish. The authority for that is available in the bundle if the panel would like to review it. However, if you wish, I can continue. I'm obliged. The Pioneer container is in fact one step removed from the instant case. In the instant case, there is a sub-bailment. It's submitted that Spectre International has confirmed that sub-bailment does result in a bailor-bailee relationship, and that in the instant case, although no express permission or express consent was given, Spectre is a similar case involving haulage and long distances. It is analogous to the instant case, and therefore it is submitted that sub-bailment in the instant case applies. The Cruisy Shipping there are 2 submissions on the bailment proposal. The first submission is that Cruisy had the opportunity to include a jurisdiction clause and failed to do so. Alternatively, Cruisy Shipping did have consent from the bailor to subcontract on any terms. However, Imagine Imaging, as the bailor, were only issuing a consent to any terms on the basis that there was an existing jurisdiction clause contained through the incorporation of the arbitration clause, clause 25 on page 9 of the facts.
Why isn't the choice of South Africa an ouster provision?
It is submitted on that point that the jurisdiction clause included in the standard terms and conditions by Cruisey Shipping addresses only litigation and not arbitration. Contractual clauses should be given their natural and ordinary meaning, and litigation involves a lawsuit, and a lawsuit is prosecuted in a court of law.
Can you point to the particular provision that leads to that effect?
I'm sorry, Mr. Arbitrator?
Provision that leads to that effect?
A particular provision that leads to that effect? I'm terribly sorry, I'm not quite sure I'm with you.
What's the basis on which you say that flows? The proposition that you've... That is limited to litigation.
Oh, that it's limited. As I said a moment ago, the proposition is that contractual clauses should be given their natural and ordinary meaning, and that litigation in the Oxford English Dictionary is defined as involving the prosecution of a lawsuit. And a lawsuit is defined in the Oxford English Dictionary as being prosecuted in a court of law. And an arbitration panel, an arbitration is entirely and specifically not a court of law. So that is the submission on that point.
And there's no authority on clauses like clause 12 of the standard terms and conditions that would support your proposition?
The
Then a clause like clause 12 leaves room for an arbitration clause, no matter how arising.
The submission on that point is that there has to be certainty in international trade and carriage of goods by sea due to the diverse nature of the contracts and the number of parties involved. Imagine Imaging were the instigators of the head contract with fast forwarders, and therefore they would be aware that there were further parties involved. They ensured there was an arbitration clause for any dispute arising that was based on the foundation of the head contract. Excuse me.
There is, of course, another side to that coin, isn't there? The shippers and exporters equally have to be sure that their goods can be treated properly if they're going to be encouraged to engage in international trade.
Yes, the Imagine Imaging have ensured that there's an arbitration clause that specifies the jurisdiction, and at the time that the contract is concluded or negotiated by Imagine Imaging and fast forwarders, they are not able to ascertain the rest of the parties involved, and therefore they have introduced an arbitration clause. And when they have consented to subcontractors being appointed on any terms, it is submitted that they have in their contemplation the jurisdiction clause contained in the arbitration, and therefore it's on any terms. Subcontractors may be appointed by fast forwarders on any terms, subject to the jurisdiction clause contained in the arbitration.
Is it subject to any other clauses? This looks to me like picking apart the on any terms through the disintegration of exceptions. Is it only the arbitration clause that trumps on any terms, or are there other clauses as well?
It is submitted that the arbitration clause and other clauses could be included with the on any terms principle. There has to be, for commercial certainty, there has to be a situation where Imagine Imaging, as owners of the goods, are able to take an action. It is submitted.
But how much of the specific provisions of that agreement are overcome by the on any terms provision? Or is it just the arbitration clause that...
The arbitration clause is a mutually beneficial clause, and so it is submitted that that is included purely to ensure that when disputes arise, it will be included. I would withdraw the submission that any other terms could be included.
So just the arbitration clause?
I would it is submitted that it's limited to the arbitration clause. So, under bailment, the arbitration clause is included through the fact that Cruzy did not negotiate on that clause, and they did not identify further that there were parties above them in the contractual chain, and yet they will have been aware of that. That is illustrated by the fact that they've put in their standard terms and conditions a clause that seeks to identify the jurisdiction for litigation. I would turn to the agency relationship that's established from the Euromidden. The Euromidden established that benefits can be conferred down the contractual chain to third parties that are not privy to a contract through the inclusion of a Himalaya clause. Midlands and Scruton contains 4 conditions that should be met for that principle of agency to apply.
Who's the third party here?
The third party in this instance is Cruzy Shipping.
Right, and what you're saying is the arbitration clause is a benefit being conferred on them?
As I have mentioned, I've moved to the agency point. I'm not saying it is not submitted that the arbitration clause is of a benefit solely to Cruzy Shipping. It's a benefit to Cruzy Shipping, but also a mutual benefit to Imaging or fast forwarders.
It's not like it's not like the exclusion clauses that are usually the subject of the Euromidden. How's pronounced that doctrine?
The Euromidden applies to benefits. Thank you. The Euromidden applies to benefits for the third party. The arbitration clause would be a mutual benefit, and therefore is not a single benefit running from one party to the other, a unilateral benefit, as it were. The clause for arbitration is a mutual benefit. The benefit to Cruzy in this instance is the exclusion clause, or limitation clauses rather, clause 1 and clause 14.1 in the contract negotiated between fast forwarders and Imaging.
But of course, and that's the sort of bundle rights argument, isn't it? That if you're going to take the benefit of that exclusion clause, you've also got to take the arbitration clause that goes along with it, right?
That is correct. That is the...
But what if they don't? What if they have no intention of relying on any such exclusion clause, but rather than on their own exclusion clauses in their contract with Ken's de-stuffing, that wonderful descriptor?
The fact that they don't intend to take a benefit doesn't negate a benefit being available. On clause 4... Sorry?
It's an odd benefit, isn't it, that you're forced to take?
Cruzy Shipping are forced to take. Well,
in order to make the Euromidden argument run, which, as I understand it, is what you're putting to it.
the Euromidden principle establishes a collateral contract by agency. The point of jurisdiction is established through the collateral contract having to have a jurisdiction. It must have a jurisdiction. It is submitted that the jurisdiction is taken from the head contract. The head contract establishes the jurisdiction through the arbitration clause. Forgive me, I would like to move finally to the ad hoc agreement point, which I would like to include in my argument. It is submitted that Cruzy Shipping acquiesced when notice was given by the claimant, and therefore there is an ad hoc agreement to arbitration in England. There was notice given in the letter by Imaging to Cruzy Shipping. It could be argued, using the Atlantica, that the notice given included a threat, but it is submitted that that is not the case. given the fact that the Atlantica mentions that those people involved in, those organisations involved in arbitration frequently have not taken legal advice, it is submitted that Imagine Imaging have termed their letter in absolutely normal language for a business organisation, and that it is not a specific threat. It is just the language that they might use if given legal advice. They might have changed the exact nature of what they said, but it is submitted that due notice has been given. Unless I can be any further assistance to the panel.
Take us to that letter that you're talking about.
I'm terribly sorry, I'm not hearing.
Take us to that letter you're talking about.
In the bundle of facts, if I might take a moment to just check.
Is it the one at page 51, the letter dated 1 December 2005?
I believe that is the letter, Mr. Arbitrator, and I'm obliged. Yes. It is conceded that it could be argued that that letter does constitute a threat, and that therefore it would fail to comply with the needs of notice, but it is submitted, as previously mentioned, that it is in the normal business language used and is entirely normal on that basis. And that given that the Atlantica says that you should look to the substance rather than the form, we would submit that it should not be negated as notice.
It's rather putting the cart before the horse, isn't it? If you're dealing with an ad hoc agreement, you're looking for the parameters of an agreement. The way you're putting it is there's pre-existing arbitration clause agreement on foot, and the notice is sufficient to therefore activate it and to get a response. But on this point, you're really talking in terms of acquiescence or waiver rather than agreement, aren't you?
That does constitute our submission on that point. Unless I can be of any further assistance, that concludes my submissions on the jurisdiction.
Thank you, Mr. Jones.
Thank you.
Now, is it agreed that we proceed with the second limb of your submissions, or is it to be responded to by the other side?
We would be happy to proceed on that basis.
Friends are equally happy?
I think the respondent would prefer to deal with the point of jurisdiction, perhaps while it is fresh in the minds of the tribunal, but if it pleases the tribunal to move to the substantive issues.
Well, you're happy if we do it that way? We deal with the jurisdiction first?
We have no objection.
Very well. Happy to?
Yes, I could.
Yes, all right, well, we'll do it that way.
Thank you. Thank you, Mr. Chairman. The respondent's contention is that there is no binding arbitration agreement between the claimant and the respondent, and hence this tribunal has no jurisdiction to hear the substantive issues in dispute. The first point that we make on our outline at 1.1 is that this tribunal does indeed have the power, and we concede that, to determine whether it has jurisdiction. It is competent to determine that jurisdiction under Section 30 of the Arbitration Act of 1996. The respondent intends to rebut the 3 points put forward by the claimant. The first being that the respondent is bound to arbitrate by the doctrine of sub-bailment on terms. The second, that the respondent is bound to arbitrate through a collateral contract. And the third, which I believe is an alternative submission by the claimant, that an ad hoc agreement to arbitrate arises. If I could move first to the point of bailment. The respondent draws a distinction between two different contracts, and those are the two contracts that come before this tribunal. The first is found on page 9 of the materials.
Of your materials?
Of the facts of the problem, Mr. Chairman. Those are the terms and conditions of a contract between Imagine Imaging and Fast Forwarders. And perhaps if we call that the head contract, that will be the most convenient. Then on page 45 are the terms of the second important contract here, which is the standard terms and conditions of the contract between Cruisy Shipping Support and Kensey Stuffers. And those are, of course, the terms of the sub-bailment. And the respondent agrees with the claimant that those are the terms of the sub-bailment. The contention of the respondent is that the doctrine of sub-bailment on terms means that those terms of the sub-bailment bind the bailor, but the terms of the head contract do not bind the sub-bailee. That was held by the House of Lords in the Pioneer container. If I can take you to that now, in the small bundle of materials that the respondent has provided you with, behind the second orange tab, is the case of the Pioneer container. If I could take the members of the tribunal to page 347 of that case. On the right hand, behind the second orange tab,
Second orange, yes. got
yes,
that.
page 347 of the case. On the right hand column, 3 lines down from the top, they are talking there about a case called the Forum Craftsman, on which the respondent relies. It says, it was not, therefore, a case where sub-bailees were seeking to enforce against the owners of the goods an exclusive jurisdiction clause in the contract governing the sub-bailent, which has been consented to by the owners. It was a case in which the owners of the goods were seeking to enforce against the sub-bailees an exclusive jurisdiction clause in their contract. And a little further down, it was scarcely surprising that, in these circumstances, the Court of Appeal declined to hold that the ship owners were bound by the clause. So, in that case, in the Forum Craftsman, it was the owner of the goods trying to impose a term of the head contract on the sub-bailees. And because those sub-bailees did not consent to that term, and because they were further down the contractual chain, and therefore there was no evidence of consent, they were not bound by any terms of the head contract. In the respondent's submission, that is the situation that we have before us today. There is a clause in a head contract that the claimant would like to apply to the respondent. Simply by inserting an arbitration clause in a head contract, that does not mean that every party who has possession or takes control of the goods will be bound by it. There must be some mechanism. The mechanism that the claimant puts is sub-bailment. However, that only allows the terms that we have agreed with a lower party to bind the bailor. Under the authority of the Privy Council, the respondent says that there is no authority to say that terms of the head contract can bind a sub-bailee, in the absence of privity, of course. If there are no further questions on that from the tribunal, I may move to the second of the respondent's submissions, and that is on the collateral contract submission of the claimant. This submission is noted at point 1.2, I apologise, in the outline of argument which the respondent has provided, and has 2 limbs. The first is that the arbitration agreement cannot be applied to the respondent because it does not fit within the terms of the Himalaya clause, which is within the head contract. If I can take the members of the tribunal again to page 9 of the materials, you'll see at the bottom of that page the arbitration agreement, of which the dispute arises as to jurisdiction. And in clause 8, also on that page, there is a Himalaya clause, which states that third-party agents, representatives and subcontractors are to have the benefit of certain types of clauses: defences, privileges, rights, exemptions, limitations, immunities, liberties and conditions. The claimant submitted that that clause allowed the arbitration agreement to be offered to the respondent through the agency of fast forwarders, and that fast forwarders was acting as the agent for that purpose. The respondent says that because an arbitration clause is not one of those terms, it is not a defence, a privilege, a right, an exemption, a limitation. Because it is not one of those terms, it has never been extended to third parties. That Himalaya clause, the purpose of inserting a Himalaya...
Wasn't a condition.
If I could take Mr. Arbitrator to the case of the Maritime, it was held that when there is a wide word or a more general word such as condition, it is to be limited in its scope, in its meaning, to the more general, the more specific words, I apologise, that precede it. That follows the Latin maxim of a istum generis. And
So being more specific, why is a right and exemption of the same nature?
we say that the preceding words, from defence to liberty, are all benefits that are one-way benefits, in that they are extended to a third party and there is no obligation put on the third party to do anything. We say that all those... I apologise?
What about the word liberty?
Yes, we say that that is also a part of that. For example, if there was a liberty for a subcontractor to do something, that would be a right that is put on that person, rather than an obligation that the third party owes back. So we say the class of terms is one where rights are given to third parties, or benefits, things that they don't need to do anything to have the benefit of.
But why is the genus set by the words you describe? Or to turn it around, if you've got a Latin turn of mind, why isn't the appropriate maxim generalia specialis non derogate?
I apologise, my Latin is not
In other
sufficient.
words, why should the special words be taken to cut down the general words?
We rest on the authority of the Maritime. There, the Privy Council held that the word provision and the meaning of the word provision would be limited to terms that benefited the third party, for exactly the reason that the respondent puts forward this afternoon.
Did the clause in that case have exactly the same linguistic structure as this clause?
It did not. Rather, it had less words before the more general word. If I can take you to that case. It is behind the first green tab of the respondent.
Green tab, yes.
Yes.
In particular?
If I could have just one moment. On page 666, members of the tribunal, the second paragraph. First of all, it cannot, in their lordship's opinion, be an exception, limitation, condition, or liberty. Those were the words that preceded the word provision. And then they go on to say, but can it be a provision? And then in that following paragraph, that is where they cut down the meaning of the word provision to be limited to the class of the other words.
So provision was the word being cut down,
Yes.
not condition.
No, Mr. Arbitrator. However, the respondent submits that it is analogous because it is a more general word at the end of a chain of specific words, and therefore...
And you'd say that would do exactly the same thing to the agency provision that occurs right at the end of clause 8. That is to say, the agency being created, assuming you could otherwise create an agency of that sort in that way, only applies for the purposes of the preceding words in clause 8, that is to say, for purposes of these privileges and conditions and liberties and such.
We say that fast forwarder's agency for the respondent may be of wider scope than those clauses. Rather, what those clauses do is define what terms are extended for the benefit of third parties. So they determine what the claimant has offered to third parties through this contract, rather than determining the scope of the agency of fast forwarders for the respondent.
Aren't they the same thing? That is what they can offer through an agency as opposed to what they can offer.
Yes, in effect. Perhaps if I could...
I'm sorry, if that's the case, if fast forwarders are the agent of the various people named there, and if there are sub-agencies that can be created, I acknowledge that's a different issue, why, and it is effective, why could it then not be said that Ken's de Stuffers, the sub-agent,
Yes.
had authority, which it exercised, to bind cruising shipping to the terms of the head contract, as you call it, or its terms.
We say that there is not a sub-agency relationship.
Right.
The reason that that cannot occur is because an agent, in the absence of clear words, cannot delegate their authority to act as agent. Although fast
Ooh, I have
forwarders...
difficulty with that proposition.
Perhaps if I can elaborate.
Yes.
Although fast forwarders was given the authority to subcontract on any terms, they were not given the authority expressly to subcontract to create an agent who could then bind the claimant. That is our submission. Therefore, perhaps if I can make one more point, the idea of having an agent is one that gives a lot of power to a third party to bind through contract. In the absence of clear words, we say that it cannot be assumed that you would give that power to another to create a sub-agent, and that clear words would be needed. Hence, we say that Kensdy Stuffers did not have the authority to bind the claimant to the terms of the bottom contract. However, Mr.
Or the other way around. Or neither did Kennedy Stuffers have the authority to bind the respondent to the terms of the head contract.
Yes,
All right.
indeed. I see that my time has elapsed. If I might be permitted perhaps 5 minutes to conclude.
Not yet elapsed, I think.
I apologise. I must have mistook the sign.
Wishful
That was
thinking.
10 minutes. That was 10 minutes on.
Thank you. Perhaps if I can go to the second point that we make, which is again an agency point, and that is that the scope of the fast forwarders agency to be the recipient of an offer to the respondent does not extend to an arbitration agreement. We say that the Euromiden does establish that an intermediary may have an implied agency to be the recipient of benefits, for example, exclusion clauses. However, we say that this implied authority cannot extend to obligations that would be owed by the third party. It was held in the Maritime that a dispute resolution clause, they're an exclusive jurisdiction clause, but we say that that is analogous to an arbitration agreement, imposes mutual obligations on both parties. And that is true in that we are obliged to appear before this tribunal. We say that the scope of fast forwarders agency does not extend to binding us to obligations. We accept that fast forwarders could act as our agent to receive benefits, to receive exclusion clauses.
Do you have authority for that proposition?
We rely on the Euromiden for that proposition. There is not a particular sentence or passage in the Euromiden that states that, because that was not necessary to consider by the Privy Council in that case, because in that case only an exclusion. I
What's
apologise.
the general principle that you're applying?
The general principle is of the scope of an agency relationship, the contemplation of the parties, the intention of the respondent.
You're saying you can take a good about that.
In effect, we are not, because we do not seek to take the good. The respondent does not rely on any exclusion clause, or in fact any term of the head
It's a
contract.
matter of general proposition. I think that flowed from what you were saying.
As a matter of general proposition, yes.
So do you say that you can take a good about that generally?
Perhaps the respondent would prefer the question to be put in terms of benefits and obligations. Benefits are not always good. Obligations are not always bad. But there is a big difference between offering an option or offering a right to a third party and binding a third party. That is the distinction that we seek to draw. I see that my time has now elapsed. Perhaps if I may be permitted a 2 or 3 minute extension just to address the ad hoc agreement to arbitrate.
Yes, yes.
Thank you. I will attempt to keep it brief. The respondent first apologises that this is not on our outline. We were not aware that that point would be pushed by the claimant. If I can first take the members of the panel to section 31 of the Arbitration Act of 1996, again I apologise that that is not in our bundle. That section, if I may quote, states that an objection that the arbitral tribunal lacks substantive jurisdiction at the outset of the proceedings must be raised by a party not later than the time he takes the first step in the proceedings to contest the merits. We say that at the first step that we contested the merits, we contested jurisdiction. In our preliminary submissions, which are found at page 6 and 7 of the materials, we make our submissions on the merits in the alternative to our submissions on jurisdiction. That is the first step we have made to contest these proceedings, and therefore we have complied with section 31, part 1. We also rely on the case of LG Caltex Gasco and China National Petroleum Corporation. Now in that case, it was held that where a person before an arbitral tribunal had continuously objected to jurisdiction at every point of correspondence between the parties, and in every submission to the tribunal had made their submissions on the merits in alternative to their submissions on jurisdiction, that was sufficient for an ad hoc agreement to not arise. If I may quickly summarise the points of the respondent on jurisdiction. The respondent maintains that the doctrine of sub-bailment on terms can only bind the claimant to the contract that the respondent made with Kensdy Stuffers on page 45, and cannot bind the respondent to terms of the head contract. The second submission was that the Euromaidan mechanism of a collateral contract cannot bind the respondent to the terms on page 9, firstly because of the construction of the Himalaya clause, and secondly because of the scope of the agency of fuss forwarders.
So in summary, your argument is the only submission contained in any contract binding on us was to the jurisdiction of South African courts. We have given no contractually binding submission to arbitration in any contract that affects us, nor have we agreed for the purpose of this particular arbitration. Therefore, we shouldn't be here.
That is a very apt summary, indeed. If there are no further questions from the tribunal, that concludes the submissions on the point of jurisdiction for the respondent.
Yes, thank you, Ms. Hedge.
Thank you.
Clark.
Mr. Chairman, members of the panel, I will deal with the substantive claim, liability. My submissions can broadly be broken down into three categories, if I might outline them at the outset. The first category of submissions are firstly that a duty of care was owed by Cruisey Shipping to Imagine Imaging, either through some kind of bailment relationship or agency, as already submitted by my learned friend Mr. Dales, or on the alternative ground of liability and tort. My second series of submissions, Mr. Chairman, is that Cruisey Shipping in fact breached that duty to Imagine Imaging either by not hiring competent subcontractors or alternatively by not adequately supervising their employees during the de-stuffing. And it is my submission that the replacement strike workers were in fact employees, and so even if Cruisey were competent in hiring them, they remain by vicarious liability liable for the negligence of their employees and damage caused to the claimant Imagine Imaging. My third set of submissions, Mr. Chairman, is that firstly, the exclusion clause Cruisey Shipping rely upon in their Kensdy Stuffers contract was not validly incorporated into that contract and as such cannot be relied upon. Or in the alternative, that exclusion clause is not sufficiently broad as to cover negligence. Or in a further alternative, Mr. Chairman, that if such a clause is incorporated and does cover negligence, then it is unreasonable according to the Unfair Contract Terms Act. Those are my three categories of submission, Mr. Chairman. Necessarily some must be given more attention than others. I shall try and give more attention to perhaps the more contentious submissions. Members of the panel, my first submission is that there is a duty of care implied into the Cruisey Shipping Kensdy Stuffers contract to take reasonable care in accordance with the Supply of Goods and Services Act, Section 13. That section simply states that when a party is supplying a service in the course of business, that there is an implied term to take reasonable care and skill. In my submission, that is exactly what happened. It is conceded, Mr. Chairman, that Section 16.1 and 16.2 of that Act do state that such a term will not be implied if there are any clauses within the contract that would be inconsistent with such a term. It is again conceded that the exclusion clause Cruisey seek to rely on one interpretation would seem inconsistent with the term to take reasonable care and skill. It is my submission, however, that that is not the case, as contractual terms broadly break down into two categories. It is my submission that there are duty-defining clauses, and then there are liability-determining clauses, and that the two are in fact separate. In my submission, there is nothing inconsistent about implying a term that you take reasonable care and skill into a contract initially, and then at the second stage examining whether you can successfully exclude liability in accordance with an exclusion clause. I would rely upon the authority at tab 32 of the thick bundle of Kenyon and Baxter, which perhaps if I might take the panel briefly to a passage in that case. It's at tab 32 of the larger bundle, Mr. Chairman.
You'll forgive me, Counsel, if this doesn't have some echoes of now discredited fundamental breach law. I would have thought since Securicor seriously, that one looks at the entire contractual context to determine how the combination of what you call the duty defining and liability limiting clauses should be read so as to define the obligation. One doesn't, as it were, privilege either member of the pair.
Mr. Arbitrator, it is conceded that photo production has, to a very large extent, discredited the doctrine of fundamental breach. I would, however, re-emphasise my point broadly insofar as if the intention of the parties in this case are looked at, it is my submission that an exclusion clause is not any evidence that the parties did not intend for terms to be implied into that contract to take reasonable care and skill. It is my submission, Mr. Arbitrator, simply that the parties did not think to put any form of duty-defining clause, and that even on still good common law principles of officious bystanders or business efficacy, a bystander would of course assume that if you're going to unload some goods, there is a term that you will attempt to do so carefully.
Well, certainly that you wouldn't inflict deliberate damage. You can't jump all over the goods with heavy leather boots, for example. But why would the clause not be taken to protect Cruzy from the difficult to predict consequences of negligence litigation, a matter, of course, to which the legislature is addressing itself in many jurisdictions, including the United Kingdom?
Mr. Arbitrator, in my submission, exclusion clauses can be carefully drafted. The courts have gone to some considerable difficulty to establish a broad consistency of rules dealing with exclusion clauses, and commercial enterprises ought to realise what those rules are. In my submission, negligence liability can be excluded if done so carefully. That opportunity was open to Cruzy, as already outlined. It is one of my later submissions that through, I determine competent for want of a better term, through perhaps unwise drafting, their exclusion clause does not cover negligence, but the responsibility for that is theirs in my submission.
And the proper law of this contract is that of the United Kingdom and not of South Africa?
As already submitted by my learned friend Mr. Dales, yes, it's my submission. The law of this contract is the United Kingdom.
That's going to the aspect of the exclusionary part of the clause rather than the duty that you're talking about now.
It is my submission, Mr. Arbitrator, that the mere fact that a party puts in an exclusion clause of one form or another does not prevent there being a term implied by the Supply of Goods and Services Act. In my submission, exclusion clauses are extremely common in a commercial context, and if that were the case, the Supply of Goods and Services Act, or indeed the Supply of Goods Act, would have almost no application at all. It is my submission that it must be right that duties can still be implied, although at a subsequent date excluded. I will come to the matter subsequently of whether it has in fact successfully excluded negligence. If perhaps I might move on, however, to whether there's been a breach of duty.
Just one point before you do that. It's possible, is it not, that the draftsperson has been emboldened in relation to how he or she has treated Clause 9 by the fact that Clause 3 is a pre-existing statement by the merchant, in this case, fast forward.
Could you please enlighten me as to which page?
This is page 45.
Page 45, I'm obliged.
That it will bear all the risk in relation to the effect. Subject to what you make the words care of the contractor. Now, that may have led the draftsperson to feel that it wasn't necessary to go to such great length in Clause 9 to exclude, to show the limits of the exclusion in relation to that clause.
It is my first submission that stating that the merchant bears all risk is not determinative of the question of whether they will still treat those goods carefully, but that the risk that they in fact fail to do so will give rise to no liability. And perhaps your question is in two parts. It is also possible that the contract has to be read as a whole, and the merchant acknowledges that it bears all the risk might in fact be a legitimate criteria in applying the Canada Steamship test as to whether the clause is sufficient to apply to negligence. Perhaps if I might briefly deal with breach of duty before moving on to the matter of whether the clause does in fact apply to negligence. I'm obliged. Mr. Chairman, it is my submission that Cruzy Shipping did in fact breach their duty to take reasonable care, howsoever imposed. It's my submission that they are vicariously liable for the actions of the stevedores, as the replacement stevedores were employees and not subcontractors. There are authorities on my skeleton argument, Mr. Chairman and members of the panel, and these authorities lay down some general criteria in making a determination as to whether a worker is an employee or a subcontractor. These are the authorities of Lane and Leating Sang, firstly.
Can you just point to the evidence in the papers that leads to that conclusion?
I apologise, which conclusion, Mr. Arbitrator?
Conclusion that they're employees rather than subcontractors.
Yes, of course, at once. The criteria laid down in those cases, firstly, were that of control. Then that includes supervision, and other examples given were when and where the job will take place, who provides the equipment, for example. In my submission, the answer to all of those questions in the incident case is Cruisy Shipping. Cruisy Shipping provided the equipment for the replacement workers. Cruisy Shipping, as the unloading practices were distinctive, would needed to have supervised the replacement workers, and that further, when or where the unloading took place, again, that decision could only fall with Cruisy Shipping, and that as such, that degree of control they exercised over the replacement workers points to them being employees and not subcontractors. It is conceded the point that the replacement stevedores are employed on a temporary basis is evidence that they are subcontractors. However, to that extent, if I might take the panel to the authority of McMeechan very briefly, this is at tab 18 of the bundle. My apologies, could you please repeat the question?
An employee for a limited purpose. I'm sorry, in the interests of equal linguistic opportunity, I thought I'd thrust some Latin on you.
Regrettably, my Latin is woefully deficient, I'm afraid. If I might...
There's a well-recognised line of common law authority, isn't there, that somebody can be an employee for a particular limited purpose and for a limited time?
Yes, absolutely. That is the exact point I wish to take from the authority. If perhaps I might move on if that's accepted by the panel.
Yes, the only question that arises, though, is of course the partially competing organisation test. Now, I have to confess I haven't been keeping up as well as perhaps I should have done with the latest developments in English law. How stands the organisation test? And might on the organisation test these people be employees of SPEC, the eponymous temporary employment agents?
Mr. Arbitrator, there are some authorities to the extent that the factor of control is of perhaps not once the sacrosanct significance that it once was, and that questions of business integration are in fact legitimate considerations, and perhaps where there is equal business integration there might be dual vicarious liability. If my submissions are not accepted, I would actually still maintain there is at least dual vicarious liability, so there is at least half liability on the part of the respondent, or full liability they might. Or perhaps in the alternative, it is my submission, however, that even if the control test has to some extent been diluted by business integration, on these facts, given the overwhelming number of control factors that solely point at Cruisy Shipping, that even if there are more factors to be considered, on the factual matrix of these facts, they remain employees.
Where in the evidence, that in the documents, do you point to those particular pieces of evidence? You've mentioned them, but can you take us to the evidence that demonstrates that?
Mr. Arbitrator, the facts of the problem are regrettably not quite as elaborate as they could be. It is my submission, however, that firstly, the replacement workers had no knowledge of the distinctive unloading practices, and that is recognised in the facts, in the correspondence between the replacement agency and Cruisy. In my submission, failing to provide any guidance to replacement workers on your distinctive practices would as of itself be a negligent act.
So that's a different point as to whether they're employees or contractors. You're identifying another aspect of negligence, I assume.
Mr. Chairman, it is my Mr. Arbitrator, my apologies, it is my submission that whichever way the facts are read, and I recognise that is a matter for you as the fact-finding panel, there is negligence in either event. Either there was not adequate supervision provided for the distinctive unloading practices, in which case Cruisy have acted negligently, or in the alternative, there was supervision given in the distinctive unloading practices, and therefore there is an element of control, and therefore the workers are employees as opposed to subcontractors. Perhaps if I might make one brief submission in the alternative, in the event that the panel finds they were in fact subcontractors. It is my submission that the duty to appoint competent subcontractors extends so far as to ensure that they are competent for the job in hand. It is my submission that if in this instant case the stevedores were not competent for the job in hand, they were not versed in the distinctive unloading practices, and as such it was not a reasonable thing to do for Cruzy to try and perform the contract at any cost. If they could not unload the goods in a way that would not damage them, it is my submission that, whilst it's unfortunate, Cruzy would actually have had no alternative but to breach their contract, simply because the circumstances of the strike, whilst unfortunate, rendered reasonable and careful performance impossible. Perhaps if I might request an additional few minutes, I believe I've just about, my time's elapsed.
No objection?
No.
I'm obliged. If I might just finally for a few minutes deal with the issue of the exclusion clause, which the panel indicated some interest with earlier. Is the panel aware of the criteria of Lord Morton from Canada Steamship that a clause has to be? I'm obliged. It is my submission, firstly, that when read against Lord Morton criteria, the phrase all loss or all risk, or there is no liability for any damage to the goods caused, can legitimately apply to other heads of damage. They could, for example, apply to the intentional acts of third parties, as an example. It is recognised that Lord Morton's criteria have again to some extent been moved away from in subsequent case development. It is my submission, however, that the courts have shown less willingness to use Lord Morton's test in the context of limitation clauses that limit liability, but that the courts remain equally hostile as they ever have been to exclusion clauses. And to this extent, if I might use the authority of Elisa, this is at tab 21 of the panel's bundle. If I might briefly take the panel to tab 2 of that case. And cite a passage only briefly. Whether a clause limiting liability is effective or not is a question of that clause in the context of the contract as a whole. However, these comments subsequently turn out to be in the context of limitation clauses. If I might cite further, clauses of limitation are not regarded by the courts with the same hostility as clauses of exclusion. This case is from 1983, although it is recognised it is not the most recent authority, it is a subsequent development from Lord Morton's test. And it's my submission that those policy concerns behind distinguishing limitation clauses from exclusion clauses remains good to this day. If I might make one final submission, Mr. Chairman, that is that the exclusion clause in the contract between Cruzy Shipping and Kensdy Stuffers has not in fact been validly incorporated. It is my submission that merely the phrase, of course this contract is on our standard terms and conditions, is not sufficient to actually integrate their standard terms and conditions if Kensdy Stufford has no actual knowledge of those terms and conditions. It's my submission, in order to integrate terms and conditions, a party must have some awareness of them, and a vague reference that there are terms and conditions somewhere, although constructive knowledge is insufficient, and that in fact actual knowledge needs to be present for there to be, for those terms have been validly incorporated. And to that end, it's my submission that the terms have not been validly incorporated. And in this end, I would rely on the authority of McCutcheon to that end.
But when you say vaguely incorporated, are you referring to any particular document in that bundle of facts?
Yes, of course.
Which one?
If the panel bear with me for one moment to find the facts. That's it. Right. Yes, it is indeed 44. This contract is, of course, subject to our standard terms and conditions which are available on request. It is my submission merely pointing out that there are standard terms and conditions, and then relying on some consistent course of dealing to incorporate those clauses is not sufficient. If Kensdy Stuffers had no knowledge as to what those standard terms and conditions in fact were, then they have not been integrated.
Well, the letter refers to successful business relationship in the past. Isn't that a course of dealing?
It is a course of dealing, Mr. Arbitrator. If I might perhaps close by taking the panel to one authority to respond to that point. If I might take the panel to the authority of McCutcheon, this is at tab 16 of the bundle. And to page 16 of that tab, as stated in the top right-hand corner. My apologies, tab 16, page 6. The bottom right-hand paragraph on the right column states, they say that previous dealings between themselves and the appellant, being always on the terms of their risk note, as they call their written conditions, the contract between themselves and the appellant must be deemed to import the same conditions. In my opinion, the bare fact that there has been previous dealings between the parties does not assist the respondents at all. The fact that a man has made a contract in the same form 99 times, let alone 3 or 4 times which are here alleged, will not of itself affect the 100th contract in which that form is not used. Previous dealings are relevant only if they prove knowledge of the terms, actual and not constructive, and assent to them. In my submission, there is certainly constructive knowledge or actual knowledge that there are some terms, but there is not actually knowledge as to what these terms in fact are. And it is my submission that far-ranging exclusion clauses require more notice than merely referring to standard terms and conditions. Unless I can give any further assistance to the panel, those are my submissions with regards to liability.
That's very well. Thank you, Mr.
I'm obliged, thank you.
Mr. May.
Thank you, Mr. Chairman. Members of the panel, my submission will essentially be in 2 parts. The first will be a submission that the respondent is not liable for the damage to the claimant's goods. And the second will be an alternative submission, and that is that Clause 9 of its standard terms and conditions does in fact cover the loss. If I could turn to that first submission, and perhaps by way of introduction, it is conceded that there is a duty of care owed to the claimant in regard to its goods, but it is submitted that the respondent has not breached this duty of care. If I could perhaps first deal with the point regarding vicarious liability for the strike force workers. If I could take the panel to page 49 of the materials, the facts and the problem. In our submission, these letters do not disclose a sufficient amount of these factors.
What's the significance of the words confirm the employment of 15 workers to their employment agency?
We submit that the question of employment versus independent contractor is one of substance, and the words used by parties to describe the contract will certainly not be relevant, will not be determinative. On this basis, it is submitted that the respondent has taken reasonable steps to take care of the claimant's goods. Essentially, the position that the respondent was in when it learned of the strike of its workers was to either decide to delay the Black Pearl by not unloading and, as my friends referred to earlier, breach its contract. That was one option. The other option was to engage these workers from strike force. Now, it is true that they were put on notice that these workers were not trained in the specific unloading practices of the respondent, but they were familiar with unloading practices generally.
What about the warning that they were that there's a concern that they may not be able to guarantee their own safety or the safety of goods?
In our submission, that is, of course, one factor that would have been taken into account by the respondent. And what this panel must do effectively is to consider whether or not that was a reasonable approach to take. Again, in the context of delaying the Black Pearl and breaching its contractual obligations, a vague statement by the supplier of these employees that they may not be able to may not be able to complete the work, which could perhaps be seen in one sense as a self-serving statement, perhaps as an exclusion of liability or a statement relevant to that, to the supplier of the employee's duty of care. In that regard, it is submitted that when answering the question of what would a reasonable de-stuffer do in the position of the respondent, the answer is it would have engaged these employees from strike-proof. It is our submission that, therefore, the claimant cannot establish that the respondent failed to take reasonable steps in employing these workers.
Who are the independent contractors here? Each one of the employees or spec?
It is our submission that either of those options would be open. There is insufficient evidence on the face of these materials to determine the answer to that question. Yes.
So spec then is the independent contractor.
Yes.
Specs made certain self-serving statements on submission. Does that then serve to excuse cruisy shipping from taking into account and recognising that it has obligations as well to put these people in harm's way because they could be injured themselves, or goods belonging to third parties, almost by definition, people in harm's way. So they're both liable.
Indeed, they both owe a duty to take reasonable care. And in our submission, that of course, that statement by strike-proof employment contractors is one of the relevant facts to be taken into account in considering the steps taken by the respondent. However, as Mr. Arbitrator put it, the hint given by strike-proof contractors in our submission should have been taken with a grain of salt, or could have been taken with a grain of salt, for the reason that it is essentially a self-serving statement.
Except that the specs more likely to know its own people on cruising.
Indeed, yes. But in our submission, the respondent is in a better position to know the specific unloading practices of its organisation. If I could move then to the, perhaps if I could conclude on that first issue, it is our submission that the respondent is not vicariously liable for the strike-proof contractors, and further to this, that the respondent took reasonable steps when deciding to enter into a contract with the employment agency, because of the circumstances of the case, this was the reasonable thing to do. If I could move then to the second main issue, which I will be dealing with, and that is the issue of Clause 9. If the panel turns to page 45 of the materials, the panel will see there the clause in issue. Perhaps by way of dealing with this in a logical order, my friends for the counsel for the claimant raised in their outline an issue of invalidity of the clause under the Unfair Contracts Terms Act, and it's our submission that this point can be dealt with fairly briefly, so I'll attempt to do this now, although it's not one of the main issues in dispute, it appears. Section 26 of the Unfair Contracts Terms Act, 1977 of the United Kingdom, which is the act relied upon by the claimant, effectively excludes the operation of the act in the case of international supply contracts. Now, the requirements for an international supply contract are firstly that the contract is inter alia, one which the passage of goods will pass by virtue of that contract. That is the first element. We submit that here clearly a de-stuffing contract would involve a transmission of possession of the goods. The second element is that it is made by parties whose place of business is in different states. It is our submission that here the parties to this contract are of course in different states.
Are they? I thought chemistry stuffing and cruisy shipping were both South African.
I apologise. If this is in relation to the claimant's submission that there is an agency relationship,
I see. Mm-hmm.
in which case the claimant would be the principal and the claimant is in the United Kingdom. And the third requirement comes from subsection 4, which is effectively that the contract is formed at the relevant time. That is, while the goods are being carried by sea. In our submission, the dates here line up effectively. The 9th of May 2005 is when the goods were shipped. The 30th of July is when the contract was entered into on page 45, and the goods landed on the 12th of November 2005. So it is our submission that all three elements of that section in the Unfair Contracts Act do apply, and that therefore this contract is excluded from the Act. If I could move then to the next point that essentially the respondent must establish. Firstly, we must establish that Clause 9 does in fact bind the claimant, and secondly, we must establish that it covers the relevant loss. Moving to the issue of binding the claimant to this clause, the respondent relies essentially on the doctrine of subaminent terms that the panel has already been taken to by syndicates with the claimant and the respondent. Effectively, the doctrine provides that where the bailor consents to terms of the sub-bailment, it will be bound by those terms. These terms are, of course, the terms upon which Kensty Stuffers came into possession of the goods, and therefore they are terms of the sub-bailment. The relevant consent is to be found in our submission on page 8 of the materials. I apologise, page 9 of the materials, at clause 8. That clause provides that fast forwarders is authorised to subcontract on any terms the whole or any part of the handling, etc. In our submission, the words on any terms effectively give fast forwarders consent to subcontract these goods on the terms that they did, on the terms that Kensty Stuffers did to fast forwarders. I apologise to the respondent.
Does this also authorise, in the name of any terms, subcontracting?
In our submission it does, and we would rely in this regard for the sub-bailment link for the case relied upon by the claimant, that is Spectra and Haysoak. It is our submission that clause 8 authorises the sub-bailment to, I apologise, Kensty Stuffers. And then if the panel turns to page 41 of the materials, they'll find a similar clause, again numbered 8, where subcontracting is authorised on any terms. I apologise.
That subcontracting includes subcontracting.
Yes, that is our submission. In this regard, I would direct the panel to the facts of the Pioneer container, where virtually the same words were used in that case. On any terms, there was held to be a very wide authorisation, and only highly unusual terms would come outside the scope of that.
What were the words used concerning subcontract or subcontract?
The
Not
words
focusing on the any terms, the point about the subcontracting. In that case, what words were used?
I apologise, the Pioneer container did not involve subcontracting.
So is it analogous then?
We submit that in terms of the scope of the consent, it is virtually the same words were used. If I could briefly then deal with one final issue, and that is whether or not clause 9 of page 45 does in fact cover the loss. And we agree that, of course, it is Lord Morton's test to be applied to this clause. It is our submission that, of course, this clause does not... I apologise, members of the panel. I just recall that I've perhaps missed one step in the logical operation. The claimant did make submissions that this clause was not incorporated into the contract found on page 40, the contract evidenced in the claimant submissions in the correspondence from pages 43 to 44. It is our submission that the reference that the contract is, of course, subject to our... I see that my time has expired. Might I be permitted 4 minutes to conclude the submissions?
No objection?
No.
Yes, very well.
Thank
Very
you.
well.
The reference there to standard terms and conditions which are available on request is in our submission sufficient, and we direct the panel in this regard to the case of the English Court of Appeal in Keaton Sons & Co Limited and Carl Pryor Limited, where essentially the same thing happened. And the Court of Appeal there held that where that notice was given, even though the other party to the offer did not in fact request those terms, so the party did not in fact have actual knowledge of the terms, that was sufficient to incorporate those terms. So we submit that these terms do in fact, the terms found on page 45 are in fact incorporated into the agreement between Kensty Stuffers and the respondent. I apologise for addressing that out of order. If I could return then to the construction of clause 9. It is our submission that clause 9 does not expressly refer to negligence, and thus we must move to the second step, and that is to consider whether the words in their ordinary meaning are wide enough to cover negligence. It is our submission that the words any loss or damage are wide enough to cover all kinds of damage, regardless of how they are caused. It is our submission that additional words do not need to be inserted to make this clause effective to cover negligence.
Do you have any authority for that proposition?
In regard to an authority on similar wording, I could direct the panel to, for example, a case of BHP Petroleum Limited, British Steel quote, PLC, where all liabilities was held to include negligence. And we can see that that is not, of course, exactly the same wording. But in our submission, what the panel must do is not focus upon particular wording in different cases. What must be focused upon is the intention of the parties to this contract. In our submission, there are no alternative grounds of liability which this contract could cover. Now, the claimant referred to intentional damage inflicted by the respondent. It is our submission that Clause 9 clearly intends to exclude liability for something. The question the panel must ask is that something intentional damage on the part of the respondent or mere negligence on the part of the respondent? Would the claimant have intended, in the circumstance of the respondent intentionally inflicting damage on the goods, to not have a cause of action? It is our submission that in those circumstances, the intention of the claimant would of course be to have such an action. Therefore, it is submitted that this clause should be construed as referring to negligence and not to different situations such as intentional damage to the goods. If there are no further questions, those are the submissions.
Yes, thank you, Mr. Moot. The Tribunal thanks the Council for the interesting and helpful submissions, and we will now retire to consider our decision in the matter. Thank you.
Well done. Thank you very much.
Well done.
Save you.